You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. This series is hosted by litigation attorney Dan Small. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
Welcome back to the Trial Lawyer's Handbook podcast. We are thrilled to welcome back Scott Duval. Scott's managing director of FTI Consulting and an expert on multimedia and graphic design. Worked with trial teams for 25 years, and I've had the pleasure and the privilege of working with him on a couple of matters. Scott, welcome back. Thank you for coming back.
Thank you for having me, but the privilege is honestly mine.
I wanted to start out, we were talking in the last episode a little more thematically about the importance of graphics. I want to be a little more practical this time and start at the basics. What should an attorney look for when hiring a graphics or multimedia designer?
First and foremost, obviously a good team member, someone that can assemble with your trial team well. I think the importance of meshing is very important. However, I think a lot of it, Dan, comes down to experience. And I know many attorneys will want someone that has, quote, relevant experience as far as what kind of case it is. Hey, this is a construction defect case. I would love someone on the team that has that kind of experience. And that's important. But as you know, every case is unique. So sure, maybe it's a construction defect case, but there's an issue of, a hurricane that came through at some point and it's force majeure, stuff that, I barely understand. While topic specific experience is great, it's probably not the only consideration. I would think that experience with a similar trial team is helpful. If you're a small team, you're close knit, and you want someone who's going to roll up his or her sleeves and get in there and talk to you about kind of what your themes are, it may be important that you get someone who's accustomed to working in that environment and doing demonstrative evidence as well as sitting in a courtroom and presenting.
I sometimes worry about that because if your graphics provider knows too much about that particular area, that's not who we're presenting to. We're not presenting to people who are experts in the area. And so I want someone who is looking at it and saying, okay, how does this work? How do we explain it to a jury of my peers, not to a jury of engineers or physics experts? How does it also, you've done this around the country and around the world, how does it vary in different venues? Or do you find that it varies in different venues, how you present?
Sure. Procedurally, I would say first and foremost, experience a lot of times is based on whether it's a state case or a federal case. When you're involved in a federal matter, obviously there will be stringent deadlines that have to be adhered to. And when it's a state case, those deadlines sometimes go out the window. I see plaintiffs that just dismiss deadlines and show up with demonstratives and then ask for forgiveness and present. Some venues, say like the Eastern District of Texas, maybe gets a ton of patent cases. So there's a lot of experience on the judges in, say, Waco, Texas, that exactly what is going to happen and how procedurally it will occur. So a lot of times it's based on the type of case in that venue. I don't know if that answers it or.
Yeah, no, I think that's right. And it definitely does. I've tried cases around the country as well, and how you present varies enormously in different courts.
And Dan, let me ask you, since you're a Bostonian, doesn't the federal court in Boston typically end at an early time, like 1:30 or something? I've supported some trials there, and I seem to recall quite often they end earlier than other venues.
Yeah, different judges are different and different cases are different, but some of the judges do take the position that they need the afternoon for motions or hearings in other cases, and there are some judges who say, look, your average juror cannot sit in a chair and listen for 8 hours straight. By hour 6, 7, and 8, you're losing them slowly but surely, maybe not so slowly. I've tried cases where 9 to 5 is a short day.
Yes.
And we often go longer than that, but I've also tried cases where, as you say, we basically break for lunch and that's the break for the day. And
Right.
I think there's some wisdom to that. It is, no juror has ever sat in a chair for 8 hours and been forced to listen.
Right.
When I was a federal criminal prosecutor, I think it was a little easier because it's easier to keep people's attentions when you're talking about, drugs and murder and corruption. It's a little harder when you're talking about patents and, technology issues and some of that. So it varies is the answer. And it also is going to vary depending on whether you have a criminal case where there is a defendant in jail and there's a lot of pressure to move the trial forward. So it definitely varies. I want to talk about successes and pitfalls. What do you see from your great experience attorneys fall into when they're creating or working on demonstratives?
So I've heard at least once, but probably more than that, some attorneys will call it trial by PowerPoint. And what I mean by that is I've seen it, say, in Wilmington, Delaware Chancery Court, which they just want to get, 200 slides in front of the chancellor in that venue for their closing argument. But I think one of the common pitfalls is, hey, we care about this topic. We need the jury to care about it. And sometimes attorneys have, or trial teams have, difficulty picking out what those key concepts are. So they will try to shove a lot of information at a jury or panel. And I think sometimes it's better to take a step back and think, what are the really key concepts that we want to latch onto and build something from that versus just throwing everything up on a screen.
I can't agree with you more. You call it trial by PowerPoint. I've heard it called death by PowerPoint
Yeah.
because people seem to think that if you put a whole lot of words up on a PowerPoint slide, it's going to have an impact. In my view, after a very low threshold, every word you add to a PowerPoint slide reduces its impact, not increases its impact.
And that's, we could probably bounce back and forth on these stories. I was in a federal court in Houston, Texas. Great judge, great staff. It was a pleasure to work in this courtroom because I got one of the best compliments I think I've ever gotten. And it was a simple one. It didn't come from a client, which that's what our job is, to get, clients to be happy. But it came from the court staff who said, Scott, the jury loves you. They say you're fast and you make everything readable. And I thought, wow, that's a great compliment because
Yeah,
that was what they cared about was, can I get the information and is it there quickly and readable? And so I think sometimes we forget the most simplistic aspects of presentation, and sometimes it's just making it readable and accessible.
that's a great compliment and so very true. You talked about the importance of sort of a roadmap.
Yes.
Lawyers don't always give the jury a roadmap of where we're going.
Yeah.
Talk about that.
I really appreciate it when they, being, presenting attorneys, will create a roadmap and say, these are the 4 topics we are going to cover. And it helps, I think, anyone get through that presentation and then reminding them, here's the introduction. Now we're going to talk about the liability or the damages or whatever the roadmap is. It helps people digest the information. And I think sometimes in an effort to be economical with the number of slides and the amount of work that goes in and the focus on the content, those roadmaps kind of wind up on the editing floor, and it's not great. It's better if they can remain.
The other thing I want to talk a little bit about is video depositions. When I teach, I think I wrote the ABA's manual on preparing witnesses, and I teach about depositions and video deposition. I talk about how fortunate we are to have so many examples of incredibly smart, articulate, successful people who were such disasters in a video deposition. I used to talk about the three Bills, Bill Gates, Bill Clinton, and Bill Cosby. But there are so many more now. But I think video depositions, once upon a time, video depositions were the exception, and people would do them, to try and intimidate somebody or whatever. But I think in many cases now, they've become more the rule, and people are videotaping pretty much everything. And that leads to your work, because once you have the videotape, that doesn't help you unless you can figure out the right way to present it. So how have you found those challenges?
So video to me is one of the most challenging aspects for a team when they're in trial. If a witness isn't showing up and we've got to present it in lieu of live testimony, it's, as anyone who does this will know, a continual back and forth of designations, counter designations, and it just doesn't end until that person is presented. And revisions will happen continually. But I think that videos quite often aren't a focus, and they should be, because if a witness isn't showing up, you got a lot of work. A lot of the documents that are referred to need to be scripted into the presentation so that the jury or judge or whoever can follow along as the person refers to a document. And as well, when the person shows up live and you have the ability to impeach that witness, I think it's very powerful that a witness, sometimes it sneaks up on them. Opposing counsel really doesn't expect it. And you're able to play a snippet that then puts that witness on guard. I've seen them behave differently where they go, uh-oh, they have my entire depot. And you play a couple clips and they start to worry about, okay, I want to answer this question, but how did I answer it in my depot? And so maybe they didn't prepare well enough, or in the depot, they just didn't do a good job answering it. So I think that it's a lot of work, but there's a lot of benefit to a successful video presentation.
I think you remember in a case we worked on together, I had an expert witness who got flustered by my questioning in a deposition. And at one point, there was a strong word that he used in his report to characterize what my clients had done. And I said, that doesn't appear in any document, does it? No, you just made that up, didn't you? And without thinking, he said, yes. And his yes was forever enshrined in videotape. And ultimately, the other side actually withdrew him as an expert, I think in part because his deposition contained a number of nuggets that we would have used to our benefit.
And one last thing on this, and Dan, perhaps I don't want to put you on the spot, but if a party opponent is videotaped, if I'm not mistaken, the trial team can use that deposition, right?
Absolutely.
And so I've seen that happen, and the opposing counsel, it's happened 2, 3 times, maybe objects, and it doesn't get sustained. And that video depo is now fair game to just, hey, I'm going to play your video, tell me your thoughts at the end of it. And it's not great sometimes. So that's something that I've had come up, and it's isolated incidents, but it's pretty powerful.
It is. And when I teach these issues, I often tell people, look, too often lawyers and clients say, oh, it's just a deposition, quote unquote, without realizing that, no, this is your trial testimony. And
Correct.
Or at least it better be, and you better prepare your witnesses accordingly. And too often, even very good lawyers just don't focus as much on witness preparation, but don't get me started on that. That's a
Yeah.
whole
Yeah.
different
And
topic.
sometimes I've found that the teams will say, can you create these designations so that I can show them to this witness? I know you've done that as well, to show them, reading a transcript's helpful, but being able to see the actual clip is really great for witness prep.
Absolutely. Scott, this has been so great. I really appreciate it. Thank you for coming on board with your valuable time and wisdom. Scott Duval is a managing director of FTI Consulting and a 25+ year veteran of trials, trial teams, and trial graphics. And I can't thank you enough for coming on board.
Thank you for having me, Dan.
Thank you for listening to the Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland & Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.